for a number of years, do a lot of work, labor and employment law work. So I'm very familiar with, for example, workplace rights of both people with Parkinson's and caregivers, people that love them. Very familiar with disability benefit issues for those of you that might be interested in Social Security, long-term disability, other forms of disability benefits. We also do workers' compensation work, which I hope you don't need ever. But that's just a little bit of information about us. On a personal level, my wife's been living with multiple sclerosis since 1992. So although I don't exactly understand what it's like to have Parkinson's, I think I have a better sense of a number of the issues that you're dealing with than somebody else who might not have had that experience. So what are we going to talk about here today? So I'd like to talk about some civil rights protections for people with disabilities and people who love them, some disability benefit opportunities, issues about health insurance that you might be interested in learning a little bit more about, and then also some important legal documents that you should consider having in place if you don't have in place already. And just to let you know, I don't prepare wills and healthcare proxies I'm going to talk about, so this is not a sales pitch in any way, but it is, I do have enough knowledge to know that these documents are important, and ultimately if you had an issue or need a recommendation of somebody, I could do that, but I don't do that type of work, so I don't want you to feel like you're getting a sales pitch here. Okay. So let's first talk about public places and services. We're in a library right now. This is a public place. And so what the law says, both the state law and the federal law, is that people with disabilities are entitled to the full and equal enjoyment of this place of public accommodation. And that can sometimes include making sure that there's proper physical access to the facility, that if there's a policy that says, for example, you can't bring a dog in the facility, if there's a service dog, they may have to adjust that policy. In addition, there may be some auxiliary aids and services that have to be provided. And there are two ways to enforce a person's rights in that regard. One, the New York State Division of Human Rights enforces the state law provisions that provide or require that access. And then the federal law called the Americans with Disabilities Act, some of you may have heard about that, is essentially enforced by the United States Justice Department. So again, the idea is that people with disabilities should have the equal opportunity to enjoy public places, whether that be restaurants, gyms, or libraries. And I was very happy, as talking to Yvonne earlier, to see how nice this particular facility is as far as access, as far as parking. That's a lot of things that folks who don't have mobility impairments sometimes don't think about. So I'm very grateful to see that. That's okay. That person may be more interesting than me, but so I want to talk to you a little bit about employment-related rights. So you probably know that in the workplace, employees with disabilities and applicants with disabilities have some rights and protections. And that includes an obligation of accommodation. So you may know that under the law, a person has to be what's called a qualified person with a disability. That means they have to be able to perform the essential functions of their job, either with accommodation or without an accommodation. So what's unique about the disability discrimination laws is that's not just a you can't do, right? We all know that in New York, generally, people are what's called employees at will. If they don't have a union or an employment contract, they can be fired because they're Buffalo Bills fans, right? Not fair, not appropriate, not wise, but not illegal. And so, but the ADA and the disability discrimination laws are really unique insofar as they impose an additional obligation, that obligation of reasonable accommodation, that the employer may have to provide something to someone who has Parkinson's to enable them to have an equal opportunity to do that job. And that's really the purpose of the law. And it can be kind of tricky. There's also what's called the Family Medical Leave Act for those people that work for employers and employ 50 or more people in a 75-mile radius of where they work. There is an opportunity for 12 weeks of job protected leave that we'll talk a little bit more about. And then New York has a paid family leave law, which unfortunately does not allow a person to take time for their own health condition, but does allow them to take some time off if they need to care for a loved one, so for caregivers. And let me say, if you have any questions at all, feel free to interrupt me. I appear before a number of judges who don't let me speak any longer than they want to hear me speak. And so they just interrupt me. And sometimes they throw things at me. I'm asking not to throw anything at me, but feel free to ask any questions. What's important to me is that I answer questions that you may have. If I spend the time this morning just telling you what I think is interesting and it doesn't resonate with you, I don't feel like I've done a very good job. So feel free at any point to just raise any questions you like. So let's talk a little bit about this duty to accommodate. So ordinarily, the duty is on the employee or the applicant to disclose if they have a disability. So employers are not supposed to make any assumptions. And ordinarily, for many people, Parkinson's is an invisible disability, right? Someone can't look at you and say, you have Parkinson's disease. You may have some symptoms that might suggest to somebody that that's true, but ordinarily it is your obligation, your duty to come forward and say, I have a disability, I need an accommodation. And that is supposed to begin under the law, an interactive process between you and the employer as to what do you need and what is reasonable. And ordinarily, if what you need or what you want is reasonable, that must be provided, but not in all circumstances. I'm fond of saying that sometimes if you request the very expensive accommodation, but a less expensive accommodation would be effective for you, then the employer can provide the less expensive accommodation. And also, the employer does not have an obligation to provide an accommodation if it would constitute an undue hardship to the employer. What does that mean? Well, sometimes it means expense. Sometimes it means upending the operations. For some employers that have union contracts, if they would have to violate seniority to provide an accommodation for you, the law is pretty clear in saying that they don't have to do that. And the accommodations under the law are for the person or the applicant or the employee with disability only. It's not an accommodation for the caregiver. So if there's a caregiver and they have a loved one with Parkinson's, they're not entitled to a workplace accommodation for that, but certainly the person with the disability is. And then finally, there are both a state and federal law enforcement agencies. If someone, employer, violates the rights, the state agency, again, DHR, the New York State Division of Human Rights, that generally applies to employers who employ one or more people. Federal law generally applies only to employers who employ 15 or more people. So larger entities, federal law; smaller entities, state law. Okay. Everybody hear me okay? Okay, great. All right. Certainly.
The ADA has been around long enough that most employers probably have to make accommodations already. Are there any of those particular accommodations that have to be made that haven't been made because of Parkinson's? Can you give me an example of a Parkinson's situation that's not been covered by the ADA?
Did everybody hear that question? No? Okay, all right. So I don't have anything off the top of my head I can say it wasn't done. What's really interesting about the ADA, but also frustrating to folks, is that it is very fact specific. So it's not, if you have Parkinson's, you get X accommodation, because of course, Parkinson's expresses itself very uniquely in each person that's living with it. I imagine if I talked to each of you, that I would learn some things that might be unique to your situation. Likewise, every workplace can be different. And so what an Eastman Kodak may be required to do, University of Rochester may be required to do, Modica law firm might not be required to do. So that often is one of the joys of the law, meaning it does recognize and appreciate your unique circumstance and the employer unique circumstances, but it frustrates people because they ask me a question and I give them the usual lawyer answer. I know we have one lawyer in the room, don't cheat, Dan. But what do most lawyers say when you ask them a question? It depends, absolutely, right? And that's the first thing we learn the first day of law school, by the way. They tell us, if you don't know the answer, just say it depends. But in this case, it does truly depend. So again, it would depend in part upon how Parkinson's expresses itself in you, what job you have, what the employer needs. So I can't think of anything specific on that, but actually there is a resource out there called the Job Accommodation Network that's part of the federal government. And they actually post online job accommodation solutions that have been successful. And so it's a great database of things that if you went on and you put in Parkinson's, you'll see what some workplaces have done who have reported that, what success or lack of success they've had for people with Parkinson's. So I hope that's helpful. Great. Okay, so let's talk about the Family Medical Leave Act. So again, ordinarily, that only applies to employers that employ 50 or more people in a 75-mile radius of where you work. So if you work remotely, if you work for a huge company, but you're remote in Rochester, that would not apply generally to you. It's got to be within a 75-mile radius of where you work. And you also have some criteria where you, the employee, have to have worked at least 1,250 hours in the year before you seek to take leave. And you have to have had at least 1 year of tenure, meaning if you're in the first 6 months of your employment, you're not eligible for the Family Medical Leave Act. And what that simply does is gives you up to 12 weeks of job protected leave, where in most circumstances, the employer cannot terminate your employment. But one thing to know, it's unpaid leave. So it's not going to help you pay your bills, which can be very difficult and problematic, right? And it does apply for your health condition if you were the employee and you need time off, but it also applies for the health condition of a loved one. So if you need to care for your spouse, you can take that 12 weeks of job protected leave to do that. It also involves other issues like childbirth, paternity leave, maternity leave, things like that. And if there's a violation of the law, the United States Department of Labor is the entity for which you can file a complaint without having to hire or pay a lawyer, and they will investigate and they can take action if they believe the employer violated the law. So that's the FMLA. Again, it gives 12 weeks of job protected leave to people with disabilities, loved caregivers in many respects, either loved ones and people with disabilities, and it provides some level of job protection, but does not provide pay. Now, if you may have other sources of pay through the company, including short-term disability benefits that we'll talk a little bit about. Have people generally heard of the FMLA? Is that something? I know we throw a lot of terms around, a lot of acronyms around, but have generally people heard about that or know about that? Okay. So what New York did is New York adopted something similar. And the benefit of the New York law that's similar is, one, it applies to employers that employ less. So generally it applies to almost all employers in the state of New York, including my firm. But there is also a working requirement that you got to generally have 26 weeks of tenure. You have to work at least 6 months. Or if you're part-time, there's a certain number of days. But this law is different. It does not apply for your own serious health condition. But it does apply for childbirth. It does apply for paternity leave. It does apply for your ability or desire to care for a loved one who has a disability. And it does have a pay component. So what it does is it pays 67% of your average weekly wage, meaning what you earned roughly in the year before you sought to take the leave, up to a certain cap. So for example, in 2025, the maximum benefit a person can earn or receive while they're out on this New York paid family leave is $1,177.32 a week. And that is enforced if there's a violation, excuse me, through the New York Workers' Compensation Board. So is that something, that's a relatively new law. I think this is the 4th or 5th year it's been in place. Has anyone kind of heard about that? Is that new for most people? Okay. Something good to know about, again, it provides some pay, which is helpful, but it does exempt out people for their own health conditions. So that's the area where I think it's a little bit weak. Okay, what about disability benefits? And some of you may have some familiarity with this, and I won't go into too much detail, but there's 3 sources of Social Security benefits I just want to mention to you briefly. So there's Social Security disability, there is supplemental security income, and there is what are called auxiliary benefits, meaning the benefits that a loved one, a child, a divorced spouse, a disabled spouse can enjoy if a person is approved for Social Security benefits. And I'll talk about each of those briefly. So with respect to Social Security disability, all Social Security disability is the opportunity for a person to collect their full Social Security retirement benefit early without reduction or penalty. So for example, for people that were born in 1962, I think, or later, their full retirement age is 67. So what Social Security disability gives them is the opportunity now, when they're not 67, if they're disabled, to collect that full benefit, to not be penalized in any way. Someone to be eligible has to work and pay in the system. So sometimes there's misunderstanding. Social Security disability benefit is not a government handout. It is simply you asking for the opportunity to get the money you contributed and that your employer contributed because of your labor. You probably know when you were working, for every dollar you earned, about 7.5 cents of your dollar was withheld from you, paid in the Social Security system, and your employer has to match that. And so simply you're just asking for the opportunity to take that. So in order to qualify, though, because it's like insurance, you have to be paying in. So you have to pay Social Security taxes in and have worked recently enough. Moreover, you have to be unable to work due to disability for a continuous period of a year. So it's not enough to be out 4 or 5 months and apply. You have to be out for a year. Now, it doesn't mean you have to wait until you've been out for a year to apply, but it does mean that you will not be eligible unless you're unable to work due to disability for a continuous period of a year. The monthly benefit, it depends on how much you've worked and how much you've earned. People that have earned a lot and paid a lot in the system, their benefit is higher. People that have worked, unfortunately, I find some folks who work under the table, cash, and then they say, why is my Social Security benefit so low? Well, you didn't pay Social Security tax, and that's why it's low. So that is strictly a function of what you've worked and what you paid in and what your employer's paid in. And also, the way Social Security disability works is no one is paid for the first 5 full months they're unable to work due to disability. It's a waiting period in the law. The theory behind that is every state, including New York, has a short-term disability benefits law that generally pays you for the first 26 weeks you're unable to work due to disability. So the idea is you can have some income during that 26-week period, and if all goes smoothly and well, and rarely does it, unfortunately, you would begin to collect Social Security disability right after that ends. So that's a little bit about Social Security disability. Complicated topic. We could talk for hours about it. But I assume some of you may be on Social Security disability. Some of you may be collecting Social Security retirement benefit. But again, at any point you have any questions, just feel free to raise them. So you may have heard a concept of SSI. So sometimes people get confused between those things. So I mentioned Social Security disability. That is for someone that's worked and paid money to the system. SSI, or supplemental security income, is a benefit available for people that have never worked or never paid any money in the system. For example, children could be eligible for SSI. Parents who have raised their children and never worked outside the home can be eligible for SSI. But the criteria is different. It is a needs-based program, meaning if you have a certain amount of financial resources, you are not eligible for SSI regardless of the severity of your health. So that's what makes SSI different. Social Security disability, you can be a billionaire and still get it. You don't have to need the money. Yeah.
Is it an either or? Get Social Security and SSI?
It actually could be both. But ironically, if the Social Security disability benefit is of a certain amount, that would disqualify you. So generally, for example, it would be a person, I do have some clients that get both, but the Social Security disability benefit would generally be not more than $1,000 or about $1,200 a month or less. But SSI is, again, like a needs-based type of thing. So if now some assets of a person are exempt, they don't count against them, others are, but that's how SSI works. And the amount is kind of fixed by law. The federal government provides a chunk, and then the state provides a supplement. Right now in New York, for a single person, the SSI benefit's about $800 or so a month. And the way SSI is paid, it's paid from the date they deem you are disabled or the date you apply, whichever is later. So that's kind of how SSI works. And SSI is a needs-based, a public assistance type of benefit, whereas Social Security disability is not. Okay. Have people kind of heard of SSI? I know times people throw those terms around, and I'm not sure I fully understood those until I started practicing. Oops, sorry. But people aware of that? You're familiar with that? Okay. All right. How are we doing, folks? Okay. Doing good? Nobody's thrown anything yet, so I'm encouraged by that. Okay, thank you. All right, so auxiliary benefits. So again, people that are approved for Social Security disability and sometimes SSI, sometimes there are auxiliary benefits, meaning other benefits that are payable. So for example, for a person that has a minor child, and that's defined generally as someone who's 18 or younger, or someone who is 19 but still in high school, that person is automatically entitled to a benefit if a parent is approved for Social Security disability. And generally, the benefit payable to the children in total, in aggregate, are 50% of the base benefit of the parent. So if the parent's base benefit was $1,200, then the kids would collectively, if they're more than one child, kids would collectively get half of that, or $600 or so. So it does provide some additional assistance. That auxiliary benefit, unfortunately, goes away when the child turns 18 or 19 if they're still in high school, but there are some opportunities there as well. And also we'll get into too much detail, but as a person approved for Social Security disability, under certain circumstances, a parent who has a child who they're caring for can be eligible for benefits too. Okay, so that was Social Security disability benefits. For those people who are working at the time they become disabled, there can be a number of sources of benefits for their disability that I want to tell you a little bit about, some of which you may be familiar with. So in New York, every employer in New York is required to carry short-term disability insurance, which covers generally the first 26 weeks a person is unable to work due to disability. The New York statute, though, is absolutely awful. It's embarrassing how little it pays. It pays 50% of your usual wage, but not more than $170 a week. Anybody live on $170 a week? It's crazy. And that has not been updated. I'm pretty old. I'm almost 64 years old. I've been practicing this law for a long time. It's been that same number since I started practicing. So it's absolutely a crime that that has not been increased. And I can't explain why, other than I guess we haven't lobbied well enough to have that happen. But every employer is required to carry that. Some employers are kind enough, smart enough, to provide supplemental short-term disability where they buy a policy that would pay more than that 170 if you became disabled, but not all employers do. In addition, employers are not legally obligated to buy long-term disability, which generally protects someone if they're unable to work due to disability for 26 weeks or more. But some employers do. That was something, because of the work that I do, I felt strongly about, so we bought that for the benefit of our employees. I think it's important. And then finally, depending upon the employer you work, some employers have pensions, particularly in the public sector. So if you worked for the state of New York, the city of Rochester, the county of Monroe, that you ordinarily are part of a public pension system. And like Social Security disability, they have a disability pension that allows you sometimes to take your pension early on account of disability. So we'll talk about each of those things a little bit. So again, from the employer, this short-term disability, again, it applies to almost all New York employers, but it pays that robust maximum of $170 a week for 26 weeks. Embarrassing. Again, some folks have the enhanced short-term or long-term. It's not legally obligated. If you have those policies, ask for them, read them. And then there's a federal pension law called ERISA that applies. The point of mentioning that is that it's a little bit odd as to how you would challenge that if you were denied, and it's not particularly favorable, unfortunately. Yes?
Private long-term disability policies are often difficult to take advantage of because of this idea of pre-existing. You address that from the perspective of things to generally avoid or do that would maximize not trip over that tripwire of pre-existing.
That's a great question. So let me address it in this way. So you need to distinguish between I won't be nearly as eloquent as Kevin, but he's asking about in long-term disability clauses policies, there is typically what we call pre-existing condition, existing condition. And the question is what, if anything, can you do to maximize, to give yourself the opportunity to collect under these policies? So you need to understand the difference between long-term disability policies. There are ones called group long-term disability policies, like the ones I bought for my employees. So what is that? Those are not individually underwritten. What does that mean? That means I, on behalf of the group, buy the policy, and that they don't look at each of my employees and say, well, you might get Parkinson's, you have Parkinson's, we're going to adjust the premium, we're going to take a blood test, we're going to take a urine test. None of that happens. Everybody gets in the group, right? And those policies are generally treated differently because, one, they're offset for Social Security, meaning you don't get long-term and Social Security. You get long-term and they minus out Social Security. But also, my understanding, Kevin, and I haven't encountered this very often, is that New York, for policies written in New York, they've addressed that clause by saying that long-term carriers can only bar someone with a pre-existing clause in a group policy for 1 year. So it's not a complete bar. It used to be a complete bar, meaning that if you met the definition of a pre-existing condition, and those definitions vary in these policies, so there's not one unique definition. But if you do, there's a New York statute that I'm familiar with that says you can only bar that person from collecting for 1 year. So the first year that the carrier would otherwise be responsible for paying you, they don't have to pay you. But thereafter, they have to. Which again, prior to the implementation of that law, it was a complete bar. You were done. Now, that is different from an individual policy. So, for example, one of the things I was concerned about when I started my career was becoming disabled and using family resources and not being able to provide for my family. So I bought an individually underwritten one, which means they came in, they examined me, they got my medical records, they gave me the once over, and they set the premium based on what they thought my health was or would be into the future. Those are a little bit different. And those, I'm not sure whether that statute applies to those type of policies. And that's why when you buy those policies, it's critical to negotiate. So for example, I think, and they're very picky. So one, if you did an individual policy and you had Parkinson's, they either wouldn't insure you or the cost would be so ridiculous it wouldn't make sense to do. And so they basically just push you out of the market that way. Whereas in a group policy, again, there's no underwriting. You're in. But I actually had a fight on mine. I had like a little bit of arthritis once. I went to chiropractic once ago. Well, we're going to exclude out on your disability policy anything for a back injury or neck injury. I go, I'm not going to buy the policy. Forget it. So I had to negotiate. And actually, I think the compromise was like if I became disabled for that reason in the first year of the policy, I wouldn't get paid, but thereafter. And fortunately, I continue to live just to annoy them. And that limitation is gone. But that's the type of thing. So individually underwritten, if you have Parkinson's, it's going to be very difficult for you, almost impossible. On a group policy, you're going to be in because everybody's in. But the trick's going to be is how do they define that pre-existing condition clause and the application of that New York statute, which says, yeah, they get to take a year off, but they don't get a full elimination of their responsibility. Okay. Does that make sense? I know it's a little bit confusing. Does anybody have? Go ahead, Dan.
Many don't know if they're covered by a group policy. How can somebody find out if there's a group policy that might cover them? Especially companies.
Sure. So, yeah, so Dan's question was, sometimes people don't know whether they're covered by a group long-term disability policy, and I can underscore that by 1,000%. How many times I ask a client, do you have it? They go, I don't know.
And a follow-up question is, should you consider going part-time before you cover your long-term policy? How does that factor into?
Right. So I'll answer that too. So first of all, a well-run HR department should be able to tell you whether there's a group policy available to you. And sometimes they go, oh, we don't have it. I don't know why they wouldn't have it. So ordinarily, you should be able to get that information from the HR. Some companies have well-running internal websites that show all the benefits that are available. You can click to see what your long-term policy is. And because that is something they're not required to buy, the devil's in the details. So ordinarily, I would encourage you to read that. I've read thousands of those, which just shows I have a very boring life. I'm not sure you'd want to read the policy, but you should have me or another experienced person read that because that's often determines what your benefits are or could be. But to Dan's point, he says, what about should you try to go part-time? So that can be tricky because ordinarily a long-term disability benefit is defined as anywhere from a low of 40% to a high of 70% of your pre-disability income. And they define pre-disability income as ordinarily, what did you earn in the year before you stopped working? So if you go part-time, let's say your wages or your compensation is half of what you typically made because you're trying to still work the best that you can, your long-term disability benefit is going to be half of what it should be, right? Or what it could be. And so that's the type of thing that when I'm counseling clients and working with them, I'll say, okay, before you do anything, let's talk about this. Let's read the policy. What would be advantageous to you? The other thing that sometimes people do is, my experience, and maybe I'm lucky and get who I get to work with, people work extremely hard. So when they've got Parkinson's, they've got any kind of comprehensive difficult disease, they're trying very hard to work through it. And they'll come into me because I'm an employment lawyer too, and they're saying, I have an employment problem, I'm getting written up. And sometimes my best evaluation of what's happening is that they're about to be fired or they're pretty close to being fired. And the problem is that if they're fired before they go out of work, the long-term disability policy does not apply. You have to be an employee at the time you became disabled to collect on that policy. So more often than not, I've counseled folks to say, listen, I don't like the way this is going. I think you'd be wise to have your doctor take you out of work and then have the potential opportunity of that. On the flip side, I represent some employers that say, got a guy, he's got Parkinson's, he's really not performing very well. I don't want to let him go. And I'll say, okay, let's look at the long-term policy. Let's go to him and say, listen, this is not going in a good direction. My fear is if you want to keep trying this and it's not successful, if we let you go, you're not going to have this opportunity. We would recommend that you do that. And most employers were really good with that. Like they weren't trying to stick it to the employee, but they didn't know about that. And that's something that I generally think about. So it's absolutely critical to know, to get a copy of the policy and then have me or a qualified person review it so you know what's available to you. Okay? But that's a great question. I appreciate that. Oh, sorry. Yes, sir.
Do you know, Steve, if there are expiration dates on the group policies? In other words, if an employee reaches a certain age, that the benefit's no longer available?
So typically what occurs is that the policy talks about how long, so it sets a maximum period under which you can recover. And that maximum period depends in part upon what age you are when you become disabled. So ordinarily, if you're under 62, if you become disabled, the most policies that I've read say you collect to your normal Social Security retirement age. So you may remember that it used to be uniformly that 65 was the full Social Security retirement age, meaning at that point, there's no reduction of benefit. Then Congress, because they're so brilliant, said, well, we want some more money. We want to delay this. We don't have enough money in the pool. So younger people started having a longer full retirement age. So again, I'm not at the highest one, but people in, I think 1962 or older, their full retirement age is 67. So a lot of group policies say if you become disabled before 62, you collect to whatever your normal Social Security retirement age. Others say, because we have a number of people who are working as older people than they used to, that if you are disabled at age 64, you get 5 years worth of benefits. Or, so it depends on what the policy says, but it's not uncommon for there to be a maximum period of recovery set, and that maximum period in part depends upon when you start collecting.
The technology tells us that it's time for a break.
Oh, look at that. Perfect. Look at that. So let's do that.
Let's take a 10-minute break. So be back here at 11:43. Oh, 10 minutes, and we'll see you back here then. 12 o'clock sounds good.
Great.
Thank you.
I turn this off. I turn that off. Okay.
Yeah, turn that off.
You want to turn that off?
as well.